Do you know the value of a click? Maybe. How about a view or an impression from an influencer or your own social media content? I'm not so sure. You should really check out my friends at Eisenberg. They've got this social index, and social index gives you earned media value of all your KPIs across all the main social platforms, including TikTok. And these values are updated every day. You don't want to be stuck in 2020, do you? Over 1,000 companies have used the social index to understand the ROI of their campaigns. And if you work with a social agency, you should really ask them to incorporate earned media values into your reports. Get your earned media value for social content. Visit earnedmediavalues.com. Again, that's earnedmediavalues.com.
For all of us, it's about predicting where the consumer is going and getting half of it right.
One of the things we want to do is create ads that don't suck.
Embracing change creates great possibility.
I'm Alan Hart, and this is Marketing Today. On the show today, I've got Odia Kagan. She's a partner and chair of the GDPR Compliance and International Privacy Practice at Fox Rothschild, a U.S. national law firm. She's advised more than 200 companies of varying industries and sizes on compliance with GDPR, the California Consumer Privacy Act, and other U.S. data protection laws. On the show today, we talk quite a bit about what marketing and marketers should know about the connection with data protection generally, what's going on in the landscape with cookieless world, as well as Apple IDFA, and upcoming regulations and amendments to CCPA like the CPRA. So I hope you enjoy this conversation with Odia Kagan. Odia, welcome to the show.
Thank you. Great to be here.
Yeah, well, I thought we could start. We're going to talk a lot about privacy and data and the law. And I thought we could start with what led you to pursue privacy law or focus in this area for your career for now?
So I started with privacy back when it wasn't sort of a thing, definitely not in the US. And so originally I'm from Israel, and Israel has had a privacy law since for a while. And so I was dealing with a little bit of that there. And then I did an LLM in England, which was, well, actually Scotland, I shouldn't say England, which was specifically about telecom and privacy law and dealt with the EU approach for privacy. So that's sort of when I got to, think about and concentrate on it. And then basically, I've always been interested in tech and the interplay between tech and data and privacy. And so that's basically how it started for me.
Let's get into it. There is so much going on in the world right now. The cookieless environment is declining. We are now, you'll correct me if I get this wrong, but I think we're 3 years into GDPR, and yet we still have new states revising their privacy laws. If I'm a marketer or an ad tech company, what should I be caring about in relation to data protection generally?
The first statement is that you should be caring about it. Right? That's the baseline that we should start from. And as someone, sometimes it's interesting, as someone that does this all the time and reads all the new laws that are coming out and all the developments and everything, everything seems to me, right? Hey, it's privacy everywhere. But I understand that this is not real life, and there are real people doing actual things out there that aren't paperwork, and that has not been traditionally top of mind, definitely not in the United States because of the regulatory environment. Okay, there've been pockets. And if you are a marketer, right, that's specifically dealing with regulated industries like medical or alcohol or children or, certain aspects of financial services, even though the financial services laws are not concentrated on the marketing stuff, they're concentrated on the consumer, on the financial the application and the relationship stuff. So if you are in a regulated entity, you were thinking about it. But if you're a normal everything else and ad tech and everything, this has not been top of mind. And so the first takeaway that I think, we should get from here is that this should be top of mind. It should be top of mind because the laws never catch up with tech, but the laws are catching up with the general attitude. And also, and especially right after the pandemic, there is the public view of privacy and data, which has changed. And if there is anything that's important to marketers, it's public perception. It's what the consumers are thinking about. It's consumers' expectations. And so what's happening is, okay, there are laws and those laws may have consequences, but people are now thinking this. And so the, holy grail of marketing, right? Consumer trust is aligned with privacy compliance right now. So the first thing is, okay, you need to be thinking about it. Now, what does thinking about it mean? And there are a couple of, I'm going to sort of do the big buckets and then we can kind of drill into it. The big buckets are, number one, transparency. So you need to make it obvious to normal people without like here and afters and theretofores and see aboves what it is that you're doing with their data. And you need to make it clear and you need to make it not vague, right? You don't want to like sneak it in the back way as otherwise stated in this policy kind of thing. People need to know what is going on. And they need to know what is going on, number one, because the law says so. GDPR in Europe has been saying so for a while. CCPA, which has been in effect for a year plus, has been saying that. Now we have a new law in Virginia coming in 2023 that says that too. The FTC has also been saying it for a long time. And now people are thinking that. So one, you need to tell people what's going on in an obvious way. And that means, what is the information that you're collecting? Where is it coming from? What are you going to do with it? Why? And who are the third parties and other entities that are involved in this process? And that sounds kind of, simplistic when you list those questions. And when I send them to clients, they sort of sound simple. But then you get on the call and then you find things out. It's like, oh, we have a contest, or, oh, we have a, joint marketing campaign, or we'd like to take this and create lookalikes, or we want to do this and this and this type of targeted advertising, or we want to track the behaviors of people in the brick and mortar stores and do stuff with it, right? And all of that, not all of that. I'm going to caveat that because there are certain more sensitive things that we should talk about, but especially in the US, in most cases, the answer isn't you can't do this. In most cases, the answer is you can, but here is how you need to go about it. And so one, and the other thing that you need to and the other thing this requires to do, which is difficult, is to have a serious think about the data you're collecting. And that's sort of the second point that I want to make. So one is transparency, but two, which kind of precedes one chronologically, is you need to be mindful of what the data it is that you are collecting and why. The days of like, we're collecting data because it's nice to have and because why not, that is no longer a helpful way to go about it, even though it's easy to do and big data and things are cheap and all that. Why? Well, in Europe, in Europe, I mean, like, what do we care about Europe? We care about Europe because if you as a marketer are working with a company that is an international brand, or that is a company that caters to, especially in the tech areas, because those don't need brick and mortar stuff. If you are working for a company that caters to Europeans and has like a European footprint, even not you, they may be subject to GDPR and they care, right? So that's sort of the parenthetical. But GDPR has been saying that in Europe. And now, starting in 2023, both the California law and the Virginia law have a requirement that any processing of the information needs to be, quote, necessary and proportionate for what it is that you need to do. And also, as part of the transparency, you've got to tell people what the purposes are. So you need to know, right? You need to know at the outset. So like collecting something just because it might be helpful for some reason in the future is not helpful. And the third reason it's not helpful is that if you are now retaining data, some of this data, location, biometrics, health, mental health, sexual orientation, things like that. Those are a category called sensitive information in the new laws. And some of those things are already included in the US breach reporting laws. And so you're collecting information that you may not need. You're going to have a necessary and proportionate problem. You're going to have a transparency problem because you have no idea why you collected it. So how can you disclose it? And you may have a data breach problem because you're retaining data. And if you get hacked, and as we know, right, data breaches are not an if, they're a when. We've seen that. And so then you're collecting this liability. And so this, I think also, though, let's not be like the doom and gloom, like lawyer that depresses everybody. I think that there is also real value in doing this, again, in the context of like trust. And because if you are mindful and thinking about what data you're collecting and why and what you're doing with it, and you're communicating it effectively to your users, and this is like, you guys do the magic in the communication, then you get a better connection with your audience. And the better connection with the audience is actually even more important now than it was before with, the end of third-party cookies and everything. And we'll talk about that separately. So I think there is also, real, like, not the regulators coming to get you reasons for doing that. And the third thing that I think you need to be mindful of, which is sort of incorporated, is sharing data. How do you share it? Who do you share it with? And that is the reason for it, is that sharing has legal implications, both under GDPR in Europe and under the California and Virginia laws. In some cases, you need an opt-in in order to share. In some cases, you need to provide an opt-out of the sharing. In order to do either of those, you have to know what you are sharing and what the reason is. Because not every sharing falls under these categories. Sometimes you're sharing with a service provider that literally just facilitates this for you instead of you hiring an extra employee, right? That is not one of the opt-in, opt-out situations. But there are opt-in, opt-out situations. And that, again, requires you to kind of be more thoughtful and think through your sharing. So basically, my takeaways here is, one, be mindful that this is a thing you need to think about. And two, actually think about it and figure out, what data you are handling, and then communicate it properly with people and give people the rights that they deserve in this data in the sense of choice and control. I think that's the big picture of like, what do the data protection laws imply for marketers?
That makes a lot of sense. And to your points you've made before, at the end of the day, if I'm a marketer and I'm trying to communicate with a customer or a prospective customer, and that's really my sole intent, it's about trust. Like, can they trust that I'm going to be a good steward of the data that they give me, or that I've been a good steward of the data that I've received along the way to sell them or market to them? I think you can get lost in the legal language, the here's and the therefores, but maybe it's a big opportunity for marketers. Do you feel like it's a big opportunity for marketers to like solve this?
Yeah, I totally think it's a big opportunity. I think it's a big opportunity for two reasons. One, I think it's like, I'm sure that there is an idiom specifically about opportunity, but I remember from my like high school, I remember like necessity is the mother of invention, right? So this is like necessity is the mother of opportunity and invention, right? Like, because because of the laws and because of public opinion, I think that one, there is a necessity that has been created. Even if you put aside the legal consequences, there are PR consequences right now for privacy issues. We have seen a number of cases of companies that have been in the headlines, and we don't need to mention names, but everybody, you guys I'll read all the industry papers and everything, right? Companies are in the spotlight in not a positive way for things that either are not per se a privacy violation under the existing laws, or we haven't determined yet that it is because it's like being investigated or whatever. But they are getting dinged for, I don't know, handling location information or handling public information, which is actually personal information and things like that. And people are having bad gut reactions about it because they're sensitive to it. So I think that's part of the necessity and the opportunity, right? So, and the third piece, which we were going to talk about, which is, as everybody knows, I read Ad Exchanger as much as the next guy, right? Like every day is the end of third-party cookies is coming. The cross-tracking app in Apple is coming. It's already arrived, right? And we're looking at all the rates and opt-in rates and things. So that is also a necessity. As soon as you don't have third-party cookies to rely on, then you need to be more mindful of, number one, the so-called first-party data, which, isn't really first, it's second, right? First is me, the person whose data it is. But, the data that you're collecting, and the data that you're collecting as the brand is the data that you, the marketers, are facilitating the collection of and orchestrating the collection of and coming up with ways to collect. And so because you're now relying on this data, it is up to you, well, not up to you, but you can step up and play a positive role in doing this properly in a way that helps your client not just avoid regulatory enforcement, which, if you do that, I think that would really be nice and your clients would appreciate it. But also, escape a PR fallout. But again, right, from the positive side, like really kind of get better engagement. So that's kind of the opportunity and the risk mitigation thing. The other thing that I think, and I haven't seen, frankly, enough of it, and I really think it's an opportunity, is capitalizing on the UX experience, the UX aspect of it, right? The user experience, the customer experience, because all the privacy laws, and we are seeing this now more in the context of kids. The UK regulator, the ICO, published this thing called an age-appropriate design code for applications which are targeted at kids. And they go into depth in how you're supposed to design the interfaces and not only the privacy policy or notice, right? Which we all know that not everybody would like to read a 20-page single-space legal document for fun, kind of. So but even the actual design of the interface, of the app, of the microsite, of the contest, of whatever, right? So I think that there is and when we were talking about transparency, right? This is, I think, an opportunity to collaborate with legal and say, okay, well, we've got to say these things. Okay, which of these things are people going to be like raising their eyebrows at? I think those are maybe the ones we flag first. And how do we flag them first? How do we do that in a way that's digestible by, real human beings? And the ICO, the English regulator, they actually have on their website like a little comic thing, like a comic strip situation, like a visual representation of their app, but even other things like dashboards and opt-ins and opt-outs and buttons, like those people that know how to present things. And instead of, and this is not a blame, this is just like, there's the whole discussion on like dark patterns now, right? And dark patterns are a way to manipulate in a negative way people's choices and behaviors. So instead of, focusing successfully on that, which is how do we sneak it under the door and nobody notices, and we've got that email and we've got, the 3 more months of subscription because I couldn't for the life of me opt out. Frankly, forget the consumer protection law, which probably this falls under. And forget that. Like, do you as a marketer want the person who is still with you for the extra 3 months because you fooled them into staying? or do you want the person who's like, oh, this is like something that I'm going to opt in. I'm going to stay engaged. I'm going to I'm going to follow you on like all of your channels because your stuff's cool and because you're not annoying and creepy, right? So I think that it's totally an opportunity here because I think that marketers can really play a role in making the experience better for the consumers with respect to how their data is being used. And I think that is a win for everybody and moves the needle in the direction of privacy compliance also.
I want to tackle a couple specific issues because I still don't think a lot of people in the US understand CCPA. And then I know it's been revised or is in the process of being revised with CPRA. And I'm not even familiar with that one. Can you kind of break down those two pieces of legislation just in the US?
So CCPA, the California Consumer Privacy Act, is the first comprehensive US privacy law. So everybody is familiar with HIPAA, unless you're in like some magical planet where you don't need doctors, right? So if you've been to a doctor's office, you're familiar with HIPAA. If you ever interacted with a bank, you've gotten that weird, chart thing that is the Gramm-Leach-Bliley privacy notice about sharing information, like sharing with affiliates. Yes, no, right? The bank one. And then if you are in an industry or have kids, then you have gotten that letter from the teacher that says, we would like to use this app for your child's math and we need your authorization, right? So that's COPA, which is the children's one. But we didn't have, until like a couple of years ago, the rest, which if you look at a pie chart was something called an unregulated entity. And they were called unregulated entities because they didn't have specific privacy regulation that applied to them. And CCPA changed that. Now, CCPA is a comprehensive privacy law. It applies to something called personal information. And the definition of personal information is very broad. And that's actually something that's worth highlighting because historically, and for good reason, marketers and everybody else in the US was only mindful of something called PII, personally identifiable information, which is the term that is used in some of the US data breach laws. And it is a small subset of information, which if you're a marketer for a non-regulated entity, you never touch that data, right? You don't have social security numbers and you don't have credit cards and you don't have bank accounts with login. You just don't do that stuff. You have cookie data. And then you called the cookie data non-personal information. And by the way, tip, and none of this is legal advice and blah, blah, all that. Don't say that anymore. Don't say cookies are non-personal information because they are. They are literally listed in CCPA, IP addresses, personal information, online identifiers, personal information, browsing history, personal information, shopping history, personal information. So the scope and inferences derived from this information, meaning this person is a 35-year-old female that whatever likes makeup, that is also personal information. So that's the first thing is that's a big, big change. And CCPA only applies to the processing of personal information of Californians, right? Residents of California. But it applies to companies. There are thresholds. It also doesn't apply to every company, but it applies to a lot of companies that are outside of California because a lot of companies cater to Californians and especially with e-commerce. And I have a lot of clients that they don't even have a footprint in the US. They're outside the US and they are in scope for CCPA. So those are the two big things. And what does CCPA require? It basically requires the big buckets of things that it requires are the things that we started with, which is one, tell people what you're doing with their data. What are you collecting? Where are you collecting it from? Why are you collecting it? Who are you sharing it with? And when can I opt out of this sharing? Then there is the rights. So people have a right to a copy of their data. You can ask the company for a copy of your data. In certain circumstances, there are some exceptions. You can ask that your data be deleted. And then if the sharing of your data with a third party constitutes something called a sale, and you guys are, better with branding. So I don't know what the professionals would be saying about defining as a sale for something that in most cases is not a sale as we know it and is confusing, but it is a sale. And the definition of sale means the sharing of personal information with a third party for monetary or other valuable consideration. And so it doesn't need to be an exchange for money. It could be in exchange for things like eyeballs or analytics or things like that. And if the sharing constitutes a sale, then you need to give people the ability to opt out of that sharing. And then there's other stuff like, you need certain agreements with your service providers and certain and other sort of paperwork type stuff. But the main things are transparency and rights in the information.
A quick message from our sponsor. As more companies embrace the advantage of hiring global talent, they are realizing that benefits are still very localized and constrained by national borders. That is, until Safety Wing decided to do something about it. Safety Wing is on a mission to fix the problem of remote employee benefits by offering borderless benefits for remote and distributed teams. Safety Wing's remote health insurance works in any country, whether you live there or you're just visiting. Add anyone affiliated with your company to one simple plan that gets cheaper as you scale, and customize your policy to make it perfect for your team. Safety Wing's remote health allows companies to offer equal benefits to the whole team, no matter where they live or are located. Your team is global. Their benefits should be global too. Go to safetywing.com/remote health to learn more. That is safetywing.com/remote health. Now back to the show. Now, what's the CPRA, which is the newer part?
CPRA, the California Privacy Rights Act. This is an amendment of CCPA that was actually passed as a ballot initiative, which is a unique kind of California thing, in the elections in November of last year. And what that means is it means two things. One, it means that it had a pretty significant public support because people are the ones that voted for it. But it also means that it is going to be very difficult to amend it as opposed to normal because the legislature can't really amend it that well. So it's kind of here to stay. What is it? It is basically an amendment of CCPA, and it with the intent of making CCPA more stringent and maybe also more clear. So more stringent in the way of the following. Here are the big things that are different. Number one, CCPA does not apply to employee data. CPRA does. CPRA takes away it's a sunset clause for the carve out for employees. And so now employees need to know, the employees always needed to know about the data. They had the right to get a privacy notice on what you do with the data, but they didn't have the rights. Right? So now they have the rights. Not now. It begins January of 2023. So one is employee stuff. The second thing is there are more concepts in CPRA that are closer to the EU GDPR. One of them is what we were talking about before, which is why I wanted to preview it, is this being mindful at the outset. It's not like CCPA took the approach of, okay, businesses, you are here to do business and make a living. This is the data you collect. We're going to catch it on the back end by saying, tell us what's going on. Give us some rights in our data. CPRA says that's not enough. You need to do some thinking at the outset. Am I supposed to collect this data? Do I need it? Is it necessary for me? Is it proportionate? Do I really need all this stuff? So I'll give you an example. Necessary and proportionate is like lawyers speak, and everybody's rolling their eyes and what is that? So I'll give kind of an example that may be helpful. There is a lot of enforcement for some reason in Europe with respect to CCTV surveillance, for example, or biometrics. And in either of those situations, the thinking is, okay, I have CCTV surveillance. Do I really need to have the settings in a way that they also cover the street or they cover the windows of the adjacent building or whatever, right? Do I need that? How much is the scope of the CCTV? And when I've narrowed it, and obviously, right, the obvious example, right, can't do it in bathrooms and things like that. So one, what's the scope? Number two, do I need to retain it? What's the point of the CCTV? Am I just trying to safeguard my property, prevent theft? So once, there's been no theft and I've looked at the video, like, can I kill it? And if I need to retain it for some reason, do I need to retain it in an identified way, or can I blur the faces? Or biometrics. There has been case law in France, for example, on schools, and there's a new law actually in New York now for retail establishments and restaurants about biometrics. So the question on biometrics is, they in France in the school, why are you collecting biometrics? Can you accomplish this mission? What the thing that you need the data for? Can you make that happen using something that is less of a privacy invasion than like biometrics, which are hard to replace? So that's basically the thinking that you are supposed to think in advance. Do I need this? Yes. Okay. I need CCTV. Okay. If I need it, what can I do to accomplish it in a way that is less privacy invasive? So that's the one thing that CPRA, requires, is this kind of thinking. And then there are a couple of other concepts that are sort of more legalese, but basically there is a concept that I mentioned before of sensitive information, and you have more rights in sensitive information. It also calls out specifically sharing information for the purpose of targeted advertising. And that was a big controversy kind of under CCPA on whether or not, targeted advertising are a sale or not a sale, and do you need an opt-out, and what do you do with it? And CPRA goes, okay, well, sharing for the purpose of targeted advertising is sharing, and you have rights in connection with that. And so it sort of, solved that theoretical discussion. And then the other thing it does, again, this is again, like, call your lawyer kind of thing. You need to do things like risk assessments. And you guys, information security risk assessments are very prevalent, but this is an assessment where the risk isn't to the company. You need to make an assessment and think through and analyze where the risk is the risk to the people's privacy. And so in certain situations, you need to do that. And the other things that CPRA did is, number one, it promised additional regulations, which are supposed to give us more clarity to know what we're supposed to do and to know how to advise you guys as to what to do. And it also formed a dedicated privacy enforcement authority, which on the bright side is going to give us more guidance. And on the, I guess, maybe less bright side for, companies, is going to be focused on the privacy enforcement, right? Like, this is an agency that's going to be dedicated. That's their thing. They're going to be dedicated to privacy enforcement. They're not just going to do privacy plus, 70 other things.
If we start with like the simple pieces, which is like, be mindful of what you're doing. Why are you doing it? Communicating it. It feels like that's our best way forward, because these legislations are only going to continue. I mean, like, we haven't even gotten to Virginia yet, but like Virginia is adding a new law as well, and I would imagine other states are waiting in the wings.
Oh my God, there are privacy laws popping up, whatever, mushrooms after the rain, or however you say that. There have been dozens of privacy bills this year alone, and they keep popping up and falling back out. Right now, the contenders in the ring are Connecticut, Colorado, Alaska, and New York just resubmitted a bill. And there are also like specific laws popping up, right? Like IoT and biometrics and things like that. So I think, and that I will concede that adds also a layer of complexity, right? Like, you need to figure out which pieces of every law apply to you and what to do. And that is complicated. And that's, why you need lawyers in this. But it is true. I mean, but I've used this metaphor before, but I think it helps, especially, those of you that are doing UX. So if you think about this privacy compliance, the design of a website, and you have the back end and you have the front end, the GUI, the UX, all that stuff, right? GUI, whatever. The back end is actually very similar for all of the privacy laws. They all require you to be transparent about your data. And some of them require you to actually be mindful about what data you collect and then be transparent about it, right? And they all have rights attached to the data. And so you need to have a system that enables that right. You need to have a system that, gives a copy of the data. You need to have a system that is able to delete. You need a system that allows you to opt out. Now, who gets what is a different story, but that is kind of not the problem of the programmers programming the back end. They're just like, I'll give you an example. GDPR gives you 30 days to produce a copy of the data, and CCPA gives you 45. Now, when you program this on the back end, you don't care. You need a way to give the data. And then the customer service people, the people on the front end, they need to make sure it's happening within the 30 days or the 45. But for you, it doesn't matter, right? And like mapping out your sharing and figuring out what that is and having a list of all those relationships and knowing what those relationships are, right? The programmers just need to do that. And then, yes, on the front end, the user interface for CPRA is a little bit different than Virginia. It's a little bit different than Washington, which failed, but is probably coming back next year. It's a little bit different from GDPR. It's different than some of the other laws that are coming up. But, and so there's work, right? You need to do work. But from your perspective, right? The mindset and the collaboration with the different business units and the key points that we flagged. What are we collecting? Do we need it? Do we really need it? What do we do to minimize it a little bit? What's the purpose here? How can we communicate this, to human beings? And what rights should we, are we obligated to give people? Those are here to stay. Those are here to stay. And I think those are really the key parts of the arena that marketers play in.
There's a lot that we could start doing. I mean, like you just laid out, like asking ourselves these questions, like what are we collecting? Do we need it? I love do we really need it? Because I put myself in this bucket, right? Like you always think that more data is better, but in this case, you're putting yourself at great risk.
And the other thing that you guys are so well positioned to, and some regulators have started saying that, but you guys are so much, one of the key issues that is important in all laws is the consumer expectation. What is the consumer expecting? Even the FTC, the Federal Trade Commission, which is the de facto privacy enforcer, right, in the absence of privacy laws, they basically had a statement that said something like, if it makes somebody goes, huh? Like, how did that happen? That's not good. Right? And what does that mean that it's not good? Is it a warning? Is it a PR nightmare? Is it a privacy enforcement? Is it, a fine? Like that doesn't matter because as we said, right, in the PR arena, that's already a problem. And I think that the whole point, marketers, like my spirit animal is Don Draper. Like I wish I knew how to do what you guys do, but I know that one thing that you guys do well is figure out what people want and what people expect. And so this is another area where if you can figure out people's expectations with respect to the use of their data, that is really, really important, especially in the US, even in Europe, but in the US, if you are doing things, and there's actually language, by the way, in CCPA that says, aligned with the expectations of the consumer. Like if you are in a spot where you are doing things that people expect, they know, and they expect, and they're fine with it, that is a really good place to be.
Yeah, should be the role of the marketer to make sure that we're meeting customer expectations and managing the reputation of the brands or the companies that we're working for. So, well, I mean, this has been phenomenal. And Odia, it's always, I mean, I've got a few other questions. I want to turn the tables a little bit and talk about you and get to know you a little bit better. But like, I love how you can describe these issues and you're not using all the legal mumbo jumbo that makes my head explode. So thank you.
If you died of boredom in like your head and we all heard a thunk, on the table, that would be a really boring podcast.
Yes, it would have been. Yes, yes. Well, let's turn the tables a little bit and switch gears. I loved getting to know the folks that come on the show, and I think listeners do too, because it gives a little window into who this person is when they're not talking about the topics we talk about. So my favorite question to ask is, has there been a experience of your past that defines or makes up who you are today?
I don't think there's been like a specific experience, but I think that I am kind of, I don't know, like a fighter. Like I push through challenges. I don't know. The big one is I decided 13 years ago that I would up and move across the world, right? Here to the US. And when I did that, okay, I'm a lawyer, so I am risk averse. I did have a job offer. So I did not just come here with nothing. But I did, my husband and I basically came here. We didn't have any of the stuff that that creates your comfort zone, right? Like we didn't have friends, we didn't have doctors, we didn't have, the places that we could, like stores. We didn't have all the stuff. And so we had to create that. And I think, I try to do that in life, fight my, risk averse instinct that maybe made me a lawyer and kind of do brave things anyway.
If you were starting your path, your career all over again, what advice would you give your younger self?
I would say be more patient because things, take time. I actually had a conversation with a really good friend of mine. And I said, well, why isn't this working yet? He's like, even when you're pregnant and you're really pregnant, it still takes 9 months. Like you cannot accelerate this process. So one is be patient. And two is kind of trust yourself more, trust your instincts and be brave enough to act on them and to do what you can do.
A silly question, but I like asking it because occasionally I get good ideas to go purchase items for myself. But we've been in this weird situation the last year. I'm curious if there's an impactful purchase that you've made of, say, $100 or less in the last 6 to 12 months.
I mean, impactful is like a big word, right? But I really like makeup subscription boxes. So I got a makeup subscription box that comes with a magazine subscription too. And one, I discovered that while I may enjoy, so this one I actually did it's digital and paper. So while I kind of enjoy, looking at the magazine on the iPad, one, I forget to do it whereas the physical magazine reminds me. And two, as my 6-year-old explained to me, it's like, Mom, this one doesn't have the thing that you can smell the perfume with. And so I like fashion magazines and I really like makeup subscription box because I really like makeup. And so every month when it comes, there's new things that I can look and some of them are cool. I feel like that sparks joy in my heart. So.
Well, I think I know where we're going with this next question. Are there brands or companies or causes that you think other people should take notice of? I'm guessing Sephora is on the list.
Well, Sephora, for example, first of all, the pandemic is going to be over for me when you can try samples at Sephora again. My daughter's like, Mom, can we go and draw hearts again? Because they want me to draw hearts on the back of their hand when we go to Sephora. So, and my husband actually once wanted to send a rescue party because I was there for 4 hours. He didn't know what was going on. So, so I like that. And then the other thing, it's not really specific. It's not really a cause and it's not really a company, but I'm sort of passively exploring Instagram recently. And I realized that you can follow all of these amazing interior design and architecture companies. And I really love interior design and I really love super modern interior design. And that is very soul uplifting when you see some of these things that companies that architects and designers are doing. It's it's a very, I know that people can get engulfed in Instagram, but the few minutes where I see those things, they make me happy.
Yeah, it's like a trip to the museum on your phone.
Well, it's like travel, world travel on your phone. And and then it's other people, other people's houses. It's very cool. Very cool.
Yeah, last question for you. And I think probably have hit on this already, but what do you feel like is the largest opportunity or threat to marketers today?
So I think that the opportunity, I think it's probably worth maybe restating, but we said it. I think the opportunity is here. I think marketers they're in a position where they are able to alert companies to this issue if the companies themselves are not aware, right, to the requirements on the privacy side. You're in the position to alert them, and also in the position to create something that will put your clients, the brands, in a place where they are, number one, compliant, and then, blah, blah, regulatory enforcement, right? Like we get that, but also closer to consumer trust, closer to consumer expectations. And that was going to generate, number one, right, less likely to be a negative PR issue, but also, as we said, more likely to actually hit the results that you're looking for, which results are now much more important when you are relying on first-party data. So, I had a conversation with a marketer once. They were debating what to do, if to do an opt-in, or actually they said something like, should we delete from our system people that haven't interacted with us in X months or whatever, right? Like, can we email them again? And it was like a mix between like Europe and not. So the legal answer was a little murky, but I said, guys, like, seriously, explain this to me. Somebody has not interacted with your brand for like 6 months. Like, do you really need to like paint, like, have they not like made it clear that this is not something that's in, like, are these the people you want to pursue? Right. Or the person that, no, do you really want to unsubscribe? No, I don't. Like maybe today, tomorrow, like that, like, do you want that guy? Or do you want the guy that is like, oh, this thing makes me so happy. This is so cool. This is so interesting. I want that. Like the subscription box, right? I see this stuff. I try. It's like, oh, this lotion's really cool. I'm going to buy that. It's like, or it's like when you listen to music, it's like, wow, this is really exciting. So those are the guys you want. And when I think that this is a small piece of the puzzle in making people excited about your brands. So I think that's the opportunity.
Hi, it's Alan again. Marketing Today was created and produced by me, with support from my team and podcast editors, sound engineers, and writers at Share Your Genius. Find them at shareyourgenius.com. If you're new to Marketing Today, please feel free to write us a review on iTunes or your favorite listening platform. Don't forget to subscribe on marketingtodaypodcast.com and tell your friends and colleagues about the show. I love to hear from listeners. You can contact me on marketingtodaypodcast.com. There, you will also find complete show notes, links to what was discussed in the episode today, and you can search our archives. I'm Alan Hart, and this is Marketing Today.